A very good evening to everyone. We are delighted to welcome you in the 17th VCM of 360-degree learning series being organized by CPE Committee of ICAI. CPE is a mean by which members of the profession maintain, improve, and broaden their knowledge, skills, and develop qualities required for sustainable growth. The ICAI has been providing continued inputs to its members through seminars, lectures, workshops, technical literature, e-learning, web-based training, etc. The CPE Committee of ICAI has launched 360-degree learning series focused on updating the current core areas of CA practice. Hence, we heartily welcome you in today's VCM about reassessment under the Income Tax Act 1961 and the latest changes in the procedures and case laws under the GST law. Our eminent speakers today will talk about two topics to enhance our members' skill set to offer best-in-class professional services. The first topic being the recent developments with respect to the reassessment provisions under the Income Tax Act 1961, and the second topic being the latest changes in the procedures in the GST law and the latest case laws. I would now like to invite the chairman of the Hisar branch of NIRC of ICAI, CA Bharat Jain ji, to welcome the audience for today and also enlighten us about the efforts of the branch for CPE learning and how the CPE committee is helping to POUs for strengthening the CPE framework. Over to you, Bharat ji.
थैंक यू पुनीत जी। मैं हिसार ब्रांच की ओर से सीपी कमेटी की ओर से सभी मेंबर्स जो आज ज्वाइन किए हैं और सभी स्पीकर्स हमारे देवव्रत अरोड़ा जी एंड मिस्टर सुनील अरोड़ा जी, मैं सबका वेलकम करता हूं। जो आज का प्रोग्राम है 360 डिग्री प्रोग्राम है, जो उसमें रीअसेसमेंट अंडर आईटी एक्ट एंड लेटेस्ट चेंजेस इन प्रोसीजर्स एंड केस लॉ अंडर जीएसटी। आई वेलकम यू ऑल। सर, मैं बताना चाहूंगा कि सीपी कमेटी जो है वो लगातार प्रोग्राम करती रहती है मेंबर्स को अटेंड करने के लिए। जो लेटेस्ट टॉपिक हैं, चाहे वो इनकम टैक्स के हो, जीएसटी के या कॉस्ट अकाउंटिंग के, सीपी कमेटी इज डूइंग ए ग्रेट जॉब। और वो सभी ब्रांचेस के साथ मिलकर अलग अलग रीजन की ये प्रोग्राम करते रहते हैं। हर रोज कुछ ना कुछ प्रोग्राम इनके चलते रहते हैं, जैसे मॉर्निंग ब्लूज का है, 360 डिग्री वाला है, तो ये बहुत अच्छे प्रोग्राम कर रहे हैं। ओवर टू यू पुनीत जी।
Thank you so much, Bharat ji, for letting us know what the efforts the branch has made over a period of time. I would now like to invite the Vice Chairman of Hisar branch of NIRC of ICAI, CA Pavan Kumar Mittal ji, to introduce our speakers for today, CA Sunil Arora ji and CA Devvrat Arora ji, who shall deliberate on the recent developments with respect to reassessment provisions under the Income Tax Act 1961. Over to you, Pavan ji.
Thank you, Puneet ji. Good evening, friends. Today we have two guest speakers for the first session of today's webinar. CA Sunil Arora ji. He is a qualified chartered accountant and a postgraduate from Delhi University. He has delivered lectures on various topics of professional interest in various forums. He is also been guest faculty in a number of workshops and training programs organized by ICAI for various organizations. He was also elected as regional council member of ICAI for the term 2001 to 2004 and 2004 to 2007. Welcome you, Sunil ji. And second guest speaker of the first technical session of today's webinar, Advocate Devvrat Arora ji. He is an advocate by profession and completed LLB from Indraprasth University. He has vast experience in civil litigation and appearances before various firms and courts. He is also legal writer and researcher for legal shows. He is co-founder of the MAT Legal Aid Cell, which offers support and legal assistance to underprivileged. Welcome, Devvrat Arora ji. Hand over to Puneet ji.
So, sir, we welcome you both for today's session. Like, it's an honor to have such eminent speakers on our platform today for this topic. So, over to you, sir.
Thank you, Puneet ji. and I'm thankful to CPE committee as well as Hisar branch, and I have been my association with both these organizations has been for a number of years. CPE committee is doing a wonderful job as far as our profession is concerned. I'm sure members would agree that the kind of education which is being imparted not just by CPE committee directly, but through opening of various programs by various branches as well as study circles as well and other regional councils. I think it's doing a wonderful job. Hisar say I have had a very long relationship. In fact, I was a member of Mikasa, and that was the first time when I had the interaction with Hisar branch. And I think when the physical programs were on, I had the occasion to visit Hisar a number of times. Now, coming to the topic which has been assigned to me today. Now, as far as reassessment proceedings is concerned, reassessment of income has always been a very, I would say, contentious topic and a contentious provision. This is one subject which has seen so much litigation. I mean, other than I would say 270(11)(c), probably 148, 147 and 148 would be two sections which must have seen the maximum amount of litigation in the Income Tax Act. Now, the provisions have been there for a number of years. Major revamping of the provisions was done by the Amendment Act 1987, Direct Tax Laws Amendment Act 1987. There are innumerable judicial rulings which are there prior to the amendment and post-amendment. And now we have a completely revamped provisions with respect to the reassessment proceedings. The entire, all the relevant sections have been totally changed. That means what has happened is that we have removed the old provisions from the statute, and we have totally new sections as far as reassessment is concerned. Now let us look at why there was a need to do this. Now, if you look at the history of 148 or the judicial precedents which are there, case laws which is there, what you would find is you'll come across a number of rulings have been backed by various forums, primarily by various high courts. That means notice under section 148 is issued. After issue of notice, either immediately after the notice or after the assessment proceedings are reassessment proceedings are completed, the SSC goes in appeal. Now, when the either he files a writ before High Court or he follows the appeal procedure. Now, once the matter reaches tribunal or High Court, the challenge is for the reassessment proceedings which have been done. Now, most of the time, the reassessment proceedings which were initiated are struck down on account of the illegality in the initiation of the reassessment proceedings and not on account of merits. So a number of cases you'll find where the merits have not even been discussed by the appellate authority, and they have simply struck down the reassessment proceedings because they were invalid or there was some illegality involved or they were not compliant with the law. As a result of it, what has happened is that there was a need to revamp the entire reassessment proceedings. Second reason what I find is that there was a judgment of Honorable Apex Court of the country Supreme Court in the case of GK and Drive Shaft. Now, in this particular judgment, the Honorable Supreme Court had prescribed a certain procedure to be followed for reassessment proceedings, for initiating the reassessment proceedings. Now, unfortunately, in spite of the fact that this ruling has been there for a number of years, a number of departmental officers who were initiating the reassessment proceedings were probably not familiar with this ruling. And as a result of it, a number of reassessment proceedings were struck down due to not being in compliant with the provisions or not being in compliant with the orders of Honorable Supreme Court in the case of GK and Drive Shaft. Moreover, in the earlier provisions, we had two separate assessment procedures. One was for reassessment, and the second one was for search. Now, what has been done is under the amended provision, amended by the Finance Act 2021, we have combined the two into one. So now there is no separate provision for assessment of search cases. Now, all the search cases would also be assessed under this reassessment provisions under section 147, 148 up to 151, they will be assessed. Another challenge which the department faced was that the judgment of Honorable Delhi High Court in the case of Kabul Chawla. Now, in this particular case, the Honorable Delhi High Court held that the provisions contained under section 153A or 153C, that means with respect to search, would be restricted only to the extent of incriminating material found during the course of search. So in case any incriminating material is found with respect to an SSC or with respect to an year, the addition or the income can be assessed to that extent. The scope of 153 and 153C is not to hold a complete reassessment for all the years for which these sections were applicable. Then we had reasons to believe, which was again a very contentious issue, whether it is a reason to believe or it is reason to suspect, whether there were reasons based on which the reassessment proceedings could be initiated or not. These were again matters of debate, and in a number of cases, the department was on a back foot with respect to reasons to believe. Whether audit objections suffice a reason for initiating action under section 147 or 148 was another issue which needed to be examined. So now what has happened is, based on these challenges which was being faced by the department, now 147 has been revamped. The new section only provides that if any income chargeable to tax has escaped assessment, then the AO may assess or reassess such income subject to section 148 to 143. And an explanation also provides that AO may assess or reassess any income which has escaped assessment for any other issue which he comes across, which comes to his notice during the course of his assessment without complying with the provisions of section 148A. We'll be discussing 148A as well. So now, if we look at what has changed from the earlier 147 to now is the reasons to believe, which was there in the earlier section 147. There it talked of that where assessing officer has reasons to believe that the income has escaped assessment. Now here in this particular case, it talks of it has escaped assessment. So reasons to believe has been done away with. And the reason for removing reasons to believe is that it was again a contentious issue, and the department in a number of cases was not able to establish the reasons to believe based on which the reassessment proceedings were initiated, as a result of which the reassessment proceedings were struck down. So now we have section 147, which does not contain the provisions with respect, which does not provide for reasons to believe. I'm just running you through the various provisions, and then we'll come to the issues which are arising out of these sections. Now, section 148, by and large, the sequence of the section and by and large, the provisions remain more or less the same, but they have been totally, reintroduced, or in the sense rechanged. Now, notice for this reassessment has to be served on the SSC under section 148. Now, new provision which has been brought in is that this notice has to be served on the SSC along with orders which have been passed under section 148A(d). Now, this is a new section which has been introduced, 148A, and we'll be discussing the subclauses of this section A, B, C, D. And what is this orders? We'll be discussing it separately immediately after this. So this section, this notice, as it was there earlier also, this notice has to be served on the SSC. It is to be served along with copy of order section 148D new. This notice requires the SSC file in ITR, which has already been there. Section 148 also further provides as a notice the return has to be filed within a specified period, which was again there in the earlier provision also. Now, notice is to be issued based on information that the income has escaped assessment. The assessing officer has information which suggests that the income has escaped assessment. And this notice can be issued only with the prior approval of the specified authority. We'll be discussing who's the specified authority. Now, the issue which comes is as to what is the information. Based on what information this notice can be issued. So here, the information in section 148, the explanation provides that information which is flagged in accordance with the risk management strategy as decided by the Central Board of Direct Taxes. This is one. And second limb of this information is that final objections of C and AG will always be because these objections of any odd objections could not have been reasons to believe. So based on now the change which happened, this the information which is flagged as well as the final objection of C and AG. Now, as far as information which is flagged in accordance with the risk management strategy is concerned, here primarily what is happening is that the income tax department, that means CBDT, has taken a very long rope to decide as to what is information. I'm sure we are all aware that the income tax department is doing huge data mining these days. And when we say data mining means they have engaged softwares, agencies, and the intelligentsia enough or the mechanism to look at huge databases and to match it with the returns which have been filed by the ban, and then flagging information which possibly does not seem to be synchronizing between the two. Now, this flagged information is already there in the form of a CAS up till now. We are familiar with CAS. So now the new term which has been used here is a risk management strategy, the information which is flagged in accordance with the risk management strategy. So here, what is this risk management strategy? What information would be flagged has been left open. And this possibly would be the CBDT's call, and they would be taking a call as to what would be the risk management strategy and how the information, which information has to be flagged. Once that is decided, then this can be picked up by the department as an information. And based on this information, then further action has to be taken by the assessing officer. Now, what is the information which has to be taken by the assessing officer? Now, we'll just come to that because that is prescribed under section 148A. We have that explanation 2 is there. Now, as I said earlier, what we have done is that search cases also, instead of 153A and 153C, we have brought these search cases into reassessment proceedings now. So now the explanation 2 to section 148 provides that in a normal case, if a reassessment proceedings have to be initiated, the assessing officer should have information. What is information? I have briefly talked about it, is the information which is flagged as per the RMS, that means risk management strategy, and the final objections of CNDT is information, based on which the reassessment proceedings can be initiated. Now, as far as search cases is concerned, explanation 2 provides that they put a deeming provision there, that in the case of search, it will be deemed that the assessing officer has information, at least for 3 preceding years of the year of search, and he need not look at the data mining, he need not look at the risk management strategy. So it will be, there's a deeming fiction which has been introduced here for the first time. So now what happens is, as far as the 3 years immediately preceding the year of search is concerned, the assessing officer will be deemed to have the information. And it is not just in the search cases, it is in the case of survey under section 133A, And moreover, we are familiar that in case during the course of search, any bullion, jewelry, or any other valuable article or thing of a third party is found, then that third party used to earlier get covered under section 153C. That means the assessing officer of the SSC who was searched will pass on this asset to this information and asset to the assessing officer of the third party, and the third party 153C proceedings would be initiated. The same is the course of action which is there in case of any books of accounts or documents pertaining to or any information contained therein is related to any third party. Then third party also will be the reassessment proceedings will be initiated based on this deeming information which is there with the assessing officer, based on this explanation too. So what I'm trying to say here is that in the normal case of reassessment, there has to be information. In the case of a search or a survey or a third party whose either assets or his books of accounts or information is found during the course of search, in this case, even if no information is there, for the purpose of 148, it will be presumed or deemed that the AO has information and he can initiate reassessment proceedings with respect to these 3 years. Now we have a new section which has been introduced, which was not there earlier. This section is 148A. Now, in fact, this 148A, if you look at it, it is nothing else, but we have tried to crystallize the procedure for initiating reassessment proceedings, which was already pronounced by the Honorable Supreme Court in the case of GK and drive shaft. So now what has happened is that the ruling of Honorable Supreme Court in the case of GK and drive shaft was a judicial ruling. Now we have a section in the Income Tax Act itself which prescribes a procedure. Now, what does this section provide? Now we have 4 sub clauses here. Clause A says that the assessing officer shall conduct an inquiry if required based on the information which suggests that the income has escaped assessment. So now the working would start something like this, that the information which is there based on the data mining which will be done by the department, they'll flag the information or it will come from on the basis of the final objection of C and AG. Now this information will come to the assessing officer. Now, assessing officer, if he feels that there is some inquiry which is required, he'll take a prior approval of the specified authority and then he'll conduct an inquiry there. Inquiry regarding that particular information, whether that information is correct, whether it is valid, whether it is suggesting that the income has escaped assessment or not. Now, all these things the assessing officer would be examining. Now, once he examines this, and based on his inquiry, if he feels that he needs to proceed further, then he would obtain a prior approval from the assessing authority to issue a show cause notice to the SSC as to why 148 should not be issued in this case and give him an opportunity of being heard. He has to give him minimum 7 days and maximum 30 days. He can further extend it if at all it is required. The time period can be further extended. So now there are 2 stages, or based on information is there. Now after that 148 comes into play. Once information is there, then the inquiry has to be conducted by the assessing officer. After conducting the inquiry, he has to give an opportunity by issuing a show cause notice to the SSC. After this notice has been issued, the assessing officer will wait for the reply of the SSC. He'll consider the reply of the SSC. This is what Limb C provides. And then we have, based on this procedure which he has followed, he'll pass an order on the basis of material which is there on record to decide whether this is a fit case for issue of notice under section 148 or not. Now, there's a time frame provided that within 1 month from the end of the month in which the reply is received from the SSC, or it was supposed to be received from the SSC, this order has to be passed. Now, once this order has to be passed, then this order also has to be passed with the prior approval of the specified authority. So in other words, so this is what GK and drive shaft by and large provided. GK and drive shaft says that you'll provide reasons to believe to the SSC can file his objections. These objections have to be disposed of by passing a speaking order. and only thereafter the reassessment proceedings can proceed further, or the assessee can be reassessed. Now, exactly the same, more or less the same thing has been provided under Section 148A. So this procedure has to be followed for initiating reassessment proceedings. Now, time frame has been totally changed. What it provides is that the reassessment proceedings under the new provisions can be initiated within a period of 3 years from the end of the assessment year. Now, in addition to this, it further provides clause B, which says that the reassessment proceedings can be initiated within a period of 10 years from the end of the assessment year, provided the following conditions are fulfilled. That means the AO has in his possession books of accounts or other documents or evidence which reveal that the income chargeable to tax represented in the form of an asset has escaped assessment, and the amount of such income is or is likely to amount to more than 50 lakh rupees. So that means there are two types of reassessments which can happen. One reassessment can be of any amount. That means, and it can be on account of any reason. Let's suppose an expense has been wrongly allowed. So now this information was pointed out in the objections of C&AG, final objections of C&AGs, that one expense has been wrongly allowed to the SSE. Now, if this is the case, then within the period of 3 years, the assessing officer, after complying with the provisions of Section 148A, can issue notice under Section 148. Now, if the same thing happens, but it pertains to an expense which was incurred 5 years ago, that means the assessment has already been completed. Now, can the period or the time frame for reassessment be extended in such a case to 10 years? Now, here AO has in his possession books of accounts, other document or evidence which reveal income chargeable to tax has represented in the form of an asset exceeds rupees 50 lakhs. So one condition is that the income should be represented in the form of an asset which should have escaped assessment. Second thing is that amount which is likely to be reassessed or where the which has escaped assessment is more than 50 lakh rupees. Now, as far as asset is concerned, for clause B, the asset has been defined. Now, all these conditions are there for clause B. So there the reassessment can be up to 10 years, can go up to 10 years from the end of the assessment year. Now, for clause B, the term asset means immovable property, which can be land or building or both, shares and securities, loans and advances, and last of all, deposits in bank. So here the asset is referring to these four kinds of assets. In case they are represented in those in this form, then of course the reassessment proceedings can be initiated even up to 10 years from the end of the assessment year, and provided the income which is escaped assessment is more than 50 lakh rupees. Section 149 further provides that if reassessment proceedings under the old law had become time barred, then the same will not be revisited under these new provisions. That means the idea is not to bring in an amendment where you still open Pandora box for the earlier years. So they want to do away with that. And that is why this proviso has been added here. And as far as search cases are concerned, the new provisions would be applicable for searches which are conducted on or after 1st April 2021. For earlier search proceedings, the new reassessment proceeding sections will not apply. It will be the 153 and 153C would apply. So that means search which have happened up to 31st March 2021 will still continue to be assessed as per the provisions of section 143A and 153C. On the contrary, post 1st April search, they will get covered under the new reassessment proceedings. So these are some of the provisions which are there as far as 149 is concerned. Now we have 151, the authority who specified for taking a prior approval has also been changed now. Now they have made it, the higher authorities have been designated or given the authority to give approval for initiating the reassessment proceedings. And here what it provides is that if the reassessment proceedings are being initiated within a period of 3 years from the end of the assessment year, then the PCIT, that means Principal Commissioner of Income Tax or Principal Director or Commissioner of Income Tax or Director are authorized to give approval for initiating the reassessment proceedings. On the other hand, if it is after 3 years, then this sanctioning authority is the PCCIT. That means the principal CCIT is authorized or principal DG is authorized. It is not just director, principal director, it is principal director general who's authorized to give approval for initiating the proceedings. And in cases where the principal CCIT is not there or principal director general is not there, then the CCIT or the director general is authorized to give such an approval. I mean, this can be depending upon the jurisdiction. If the jurisdiction, there is no officer of the rank of PCCIT, then of course it can be given by the CCIT or DG if the proceedings are being initiated after a period of 3 years from the end of the assessment year, obviously up to 10 years, because beyond 10 years, the department is not authorized to look at it. Now, there are a few issues which arise here. Now, as far as 151 is concerned, the very first issue which arises is that can we, this problem was more there earlier, because earlier it was JCIT was authorized to approve the initiation of reassessment proceedings, and beyond 4 years, it was the PCIT who was authorized to give approval for initiating the reassessment proceedings. Now, what used to happen was, what happened in one of the case was that instead of taking approval from JCIT, the AO took approval from the CIT. Now, the issue was that can the reassessment proceedings, wherein the designated officer or the sanctioning authority for issue of notice was JCIT, but instead of JCIT, he took approval from CIT. Whether by mistake or JCIT was not available that time or whatever may be the reason, he took approval from CIT. He said, what is wrong with it? JCIT is authorized. If I have taken it from a higher authority, so how does it matter? Now, this issue was examined both by Bombay High Court as well as Delhi, and both of them held that the proceedings which have been initiated are invalid, because if the law provides an officer designate to do a particular task, then unless and until the task is designated to some other officer or a senior or a junior, then of course it can be done. Otherwise, the authority remains only with that particular officer, and nobody, even a higher officer, cannot step into his shoes. Now, what are the key changes? I mean, if you look at it, what are the changes which have happened as far as by the Finance Act 2021 is concerned? I've tried to list down a few changes. First of all, the entire provisions have been replaced. The old sections are gone. We have totally new provisions which are there. They are by and large, I mean, the procedures as for reassessment, these are machinery proceedings, so they are taking cue from what was existing earlier. But then in any case, all the sections have been totally replaced. We have not amended the sections, we have totally changed the sections. Secondly, the assessment of search cases has been brought under reassessment. Now, what is the implication of this, or why it was required? Now, what happened was that Section 153C started with a non-abstentive clause where it said that notwithstanding whatever is contained in 147. So what used to happen was that if at all an assessing officer, instead of initiating 153C, if he initiates 147, they were held to be invalid. Now, the assessment for the search cases, there was limitation of Kabul Chawla, which I've already discussed. So as a result of this, what has happened is that this is the idea here was so that instead of having two parallel provisions wherein the incomes are being reassessed in a way, one on account of search and one on account of other reasons based on information or where the reasons to believe are there with the assessing officer, they have tried to put them together under one provision. To my mind, this is a very rational thing to do, because there was no need for separate the search provisions, and they can very well be addressed by this reassessment proceeding itself. Third change which I find is that the timelines have been completely changed now. Completely means, yes, earlier we used to have 4 years, 6 years, and 16 years. Now 4 years were for small cases, approval from JCIT and all. 6 years was if the income escaped assessment has more than 1 lakh rupees, then of course it was 6 years. 16 years was that if a foreign asset, the income with respect to a foreign asset has escaped assessment, then the assessing officer could reassess the income up to 16 years as the law, as per the old law. Now, instead of having 4, 6, and 16, only 2 time frames have been provided. So this 16 with respect to the foreign assets, income which has escaped assessment on account of assets which are abroad. So here has been done away with. So we have 3 and 10 now. So that means up to 3 years, normal provisions for reassessment with no restriction. But in case if we want to go beyond 3 years, then it has to be income should be with respect to an asset which is specifically defined. That means immovable property, shares and securities, bank deposits. So all these form an asset. So it should with respect to an asset, it should be more than 50 lakh rupees. Only then the reassessment period can go beyond 3 years and it can go up to 10 years. Now, the issue which arises here is that when we say income represented in the form of an asset, let's suppose I had purchased a property 7, 8 years back. Now, I had not disclosed that particular property. I had purchased that particular property by my income, which was not declared to the department. Now, I had sold that property after 2 years. Now, the department comes to know of this now, and the department wants to initiate the proceeding. So the question here is that when I say represented by an asset in the form of an asset, so income represented in the form of an asset means the asset should have been there initially, or asset should be there at the time of initiating the reassessment proceedings. Now here, to my mind, the asset may not exist at the time of initiating the reassessment proceedings. That means even if I have sold that particular asset, say for example, we are talking of deposit in the bank account. Now deposit in the bank account, I may have used that particular deposit in any form subsequently after that. But if the department comes to know that there was a deposit and the deposit was there in any of the 10 years, then the department can initiate reassessment proceedings up to 10 years from the end of the assessment year to tax my income which has escaped assessment. Next is that the procedure which was prescribed by the Honorable Apex Court of the country in Jeek and Drive Shaft case has been crystallized in the form of Section 148A. Reasons to believe has been done away with. Now it is information which is suggesting has become the new norm for initiating the reassessment proceedings. All said and done, yes, that is the department seems to be doing a good job as far as this particular changes are concerned. Although I would say the speaker after me, Mr. Devrat, being a lawyer, probably may not agree with what I'm saying here. So he would probably disagree here, and we'll have an opportunity to listen to him. Yes. So now the reason and the intent for this change can be appreciated. Because what is it? I mean, the department, instead of getting into controversy of what is reasons to believe, instead of getting into controversy of whether there has been application of mind or not, I mean, that of course would be there even now. The idea is that the department should be able to reassess up to a certain time frame in case they come across any information which is suggesting that income has escaped assessment. This is what the intent is. The intent here is because I think the department has been very vociferous as far as this particular intent is concerned. Because the thing is that majority of the cases right now do not undergo a scrutiny. And most of the time, the processing is done under Section 143(1), which is done based on certain parameters. and it has become more digitized kind of a verification and disposal of the income tax returns in the form of processing, which is there. As a result of which, the income, in some cases, because the scrutiny is not happening, the department may come across subsequent information that the income has escaped assessment. The idea was to bring them under the ambit of this reassessment. But there are enough safety walls which has been built in as far as these reassessment proceedings are concerned. It is not a blatant power which has been given to the assessing officer to initiate the proceedings. Now, for this purpose, let me look at prior approval. Now, if you look at it, the word prior approval has been used in 4 places. That means section 148, 3 places. That means clause A, B, and C, A, B, and D in section 148A. And then section 148 is before issue of notice. Now, what does this mean, prior approval? Now, the manner in which the section or the clause is worded, to my mind, assessing officer will have to go to the specified authority to take approval 4 times. He cannot, the manner in which the sections are worded, it is not possible that the sanctioning authority or the specified authority can issue an approval straight away for all the 4 stages. And the manner in which it is worded, please try to understand, it says that the assessing officer may conduct inquiry if required with prior approval of the specified authority. Now, what does this mean? This means that if he gets an information, he first of all goes to the assessing officer, goes to the specified authority, takes a prior approval for initiating the inquiry. So now when he initiates the inquiry, so he collects all the information. Now this information, he decimates or he deciphers this particular information. And based on this information, he decides whether show cause notice has to be given to the SSC, whether he wants to proceed further. But there again, before he issues a show cause notice, he needs to take a prior approval from the SSC, from the specified authority. This is second approval which he needs to take. So he issues a show cause notice, he receives the reply from the assessing of SSC. He examines that particular the reply which has been received. He considers that reply and then he passes an order under section 148A(d). That means based on the material on record, he would pass an order to decide whether this is a fit case or not. But please remember that this order should also be passed only with the prior approval of the specified authority. Now, once he has passed this order, then he has to issue the notice, and the issue of notice under section 148 also, he needs to take a prior approval of the specified authority. So the manner in which the sections are drafted, I would say that the prior approval means that before conducting inquiry, before issuing show cause notice, and before passing orders, I need to take a prior approval if I'm an assessing officer. And similarly, before issuing notice under section 148, I need to take a prior approval. And there would be 4 separate approvals which would be required. And as we all know, a number of judicial precedents are there that approval cannot be mechanical. It has to be based on some application of mind by the specified authority which is there. Now, when you look at it, what is this 147, 148, the new provisions of 149, 151, whatever we have talked of? Now, if you look at it, these are only machinery provisions to initiate the reassessment proceedings. Now, as far as reassessment proceedings are concerned, there are some old rulings wherein the courts held, this was Rajasthan High Court and Bombay High Court, they held that reassessment or reopening of a completed assessment is a power which is of extraordinary nature, and therefore section 147 must be strictly construed. Although to my mind, these provisions, reassessment sections are a little harsh, or I would not say harsh, but then yes, they are giving extraordinary power to the assessing officer to reopen the assessment which has already been made. But this has got a little diluted over the years just because not much scrutiny assessments are happening, as a result of which the department's reliance on reassessment has increased. In fact, it would make more sense that the department's information system and the flagging of that information becomes that the cases are picked up for scrutiny instead of initiating the reassessment proceedings. That means what can be done in such cases is that before the due date of issue of 143.2 notice, like we have CAS, where the computer assisted the scrutiny scheme was there. So that means scrutiny cases was being decided. So this data mining or data processing, whatever needs to be done, should be done in such a manner that notice under section 143.2 is issued. But here, the department is relying upon the reassessment proceedings for primarily all this kind of data mining, whatever they are doing. Even a cash deposit. Now, why the department could not link it before the due date of issuing of 143.2, and why they did not initiate a reassessment? Why was the need for reassessment? They should have taken up the case for a scrutiny. So a case should have been taken up for scrutiny on the first instance itself by issuing notice under section 143.2. Now, the question which arises here is that the assessing officer, in spite of this, under these new provisions also, although a lot of contentious issues have been done away with, but when we look at it, there are a few issues which would still remain. So I'll just try to address in a couple of minutes a few issues, and then I'll hand over to Devrat to take up the legal issues which are involved here. Now, first of all, is the assessing officer, can he initiate the reassessment proceedings based on change of his opinion? Now, as far as change of opinion is concerned, in spite of the new new section has come, it can be done only on the basis of information. Now, information, as we've already seen, it comes from two sources. One is information which is flagged by the Central Board of Direct Taxes based on the risk management strategy which has been formulated by them. This is one. And second is the final objections of C&AG. Now, let's suppose that the assessment has been done by one of the opinions which would have been possible at that point of time. So can the assessing officer change his opinion and subsequently say that, no, I want to change my opinion, I want to reassess this particular income? Now, it was held in Calcutta Discount Company. This was a Supreme Court ruling wherein the Honorable Supreme Court said, and then there are subsequent rulings also in the case of Calculator India, that was 250 ITR 1. So now in all these cases, the primary idea was that the change of opinion by the assessing officer was not possible. Now, the same argument can be taken with respect to a one case which has been processed under section 143.1. That means no notice under section 143.2 was issued, and subsequently, the assessing officer wants to initiate reassessment proceedings in this particular case. Now, can I take a stand that if you wanted to assess my income, where is reassessment? My income is already there for you. Why you did not initiate scrutiny assessment in my case by issuing notice under section 143.2? And a thing which you could have examined in my normal assessment, why do you want to initiate a reassessment for that? So you have already formed one opinion. Let's suppose the issue is such that where two opinions are possible, and I have adopted one of the opinions. So can I say that I have taken one of the opinions, so now you cannot change your opinion, you did not issue the 143.2. Now, this issue was examined in the case of Chaveri Stockbrokers Private Limited, as well as Delhi High Court in the case of MTNL. And in both these cases, they said that 143.1 is only a processing. This is not an assessment. As a result of which, the AO has no occasion to apply his mind while the processing is taking place. And now, more so now, when the processing is done by CPC, the AO does not have the occasion to apply his mind to take a call on this. As I've already said, that in case 143.1 is by one of the opinions which was possible, but he wants to replace that particular opinion, then in that case, whether it is possible or not, the point is that if we can say that 143.1 is erroneous and the income has escaped assessment, not because of change of opinion, but because of because of escaped means, as per law, it has escaped assessment, not by saying that, okay, your opinion or my opinion, if all these things have to be done, then of course this has to be done by the up to that particular stage. So here the ruling is that change of opinion is not possible. The AO cannot change his opinion. So an assessing officer cannot sit on judgment of his own orders. So he cannot sit on his own orders, and he cannot just replace his own orders by sitting on his own judgment, or a new assessing officer cannot sit on or review his own orders. There are other provisions also which are more or less applicable on the same lines as were applicable. So the bottom line is, how does it function now? It is going to function in this particular manner. The assessing officer would get the information, and there is no dearth of information. The department has such huge database available now because practically everything has got linked with PAN, with Aadhaar. So as a result of it, there is every chance that all informations pertaining to an SSC would be available with the assessing officer at some point of time. Now, based on that information, wherever it is flagged that the income is not commensurate with the profile of the SSC for any reason whatsoever, or his income tax return is not commensurate with the information which is available with the department. So then, as per the risk management strategy, certain things would get flagged with respect to an SSC. Or if at all C&AG conducts audit in a particular case and gives such final objections with respect to certain issues there, this would constitute an information. The assessing officer, based on this information, would follow the procedure which is prescribed in the section 148A, which we have briefly talked about. And then, if at all the need be, he would serve on the SSC notice under section 148, along with orders which are passed under section 148A. This would set the ball rolling for initiating the reassessment proceedings. Now, obviously, so based on 148 notice, the SSC would file its return, and thereafter, notice under section 143(2) has to be issued, mandatorily issued by the SSC assessing officer to assess the income or reassess the income under this provision. So as I talked earlier, thereafter the normal provisions of assessment apply. So he would seek information, he would pass the orders, he would create whatever additions or whatever. But these are machinery provisions. They do not give guidelines on how the assessment has to be done, but there's only how the reassessment proceedings have to be initiated are contained in these provisions. So this was basically the new provisions with respect to the reassessment. Now, this reassessment, I'm sure at least a lot of you would be aware that this is finding huge litigation right now. And I would request Mr. Devrat Arora to take up this issues regarding the litigation as to why litigation is there. And the moderator here, Mr. Puneet Gupta, I think you can take over. So thank you. Thanks a lot.
So now I would like to welcome Mr. Devrat Arora to deliberate on the latest case laws on section 148 of the Income Tax Act. Over to you, sir.
Thank you. So like sir stated that there are various litigation that has been going on because of the reassessment notices that have been issued. And mostly these are notices which have been issued after the 31st of March, 2021. And all these notices have been challenged in various high courts. And most of the high courts have granted a stay and have set a date for hearing the matter in detail, giving the government an opportunity to come up with its reply. Now, most high courts have given a stay. There is only one exception in this, which I'll discuss in detail. But first, we need to discuss that what is the controversy and what has led to this litigation. So, right. So if we see the earlier position of section 148 before the Finance Act 2021 changed 148 and got in 148A, if we see the previous position, 148.2 said that the assessing officer has to record his reasons before issuing a notice. It simply stated that he has to record his reasons. It nowhere said, or it did not expressly anywhere imply that he has to communicate these reasons, or when and how these reasons have to be communicated to the assessee. So this is where the Supreme Court had to intervene. And they intervened in the GK and Driveshaft's case, in which they stated that the proper course of action will be that once you file your return, after that you can ask for the reasons, and then you can further elaborate upon them, and you can further state that why those reasons are incorrect. And it puts a foundation on the assessing officer. It says that the assessing officer is bound to furnish these reasons within a reasonable time. And it also further says that the assessing officer is bound to dispose of the objections, if you have any, to the reasons by passing a speaking order. So the GK and Driveshaft case, the Supreme Court tried to bring in the principles of natural justice, so that these actions are not arbitrary by the assessing officer, that these reasons are actually recorded and they are also provided to the assessee. So now understand that the assessee has the right to get these reasons. However, there was still one controversy left, which various high courts discussed, was that when are you entitled to these reasons? Are you entitled to these reasons after you get the notice and after you file your return, and then you can ask for those reasons? When can you ask for those reasons? So now different high courts have had different views in this. And if you see in the Allahabad High Court, in the Mithilesh Kumar Tripathi case, they felt that the reasons have to be provided with the notice. They felt that it is more in compliance with principles of natural justice. Because if you get a notice without the reasons, you are making, and you have to make assumptions in your head, and you are not exactly sure that why this notice has been given to me. So they felt that to avoid unnecessary litigation, to avoid confusion, the best way to go about it is to send those reasons along with the notice. And there was a lot of back and forth, and there was nothing concrete done for this. So eventually the Finance Act 2021 came into effect, and they got some changes into the Income Tax Act. So now these changes are actually very welcome changes for the assessee, and they bring an additional safeguard to the assessee. And they basically expand upon what we discussed previously, what the Supreme Court said, what the High Courts had been discussing. They bring them into writing, and they clarify any and all kind of doubts. So if we see that 148A has been added. So now what it says is, earlier when 148 only stated that he has to record his reasons before issuing notice, now it says that the provisions of 148 are subject to 148A. So compliance has to be made with 148A before a notice can be issued under 148. So now if we look into 148A in detail, it sets a 4 points to go about his notice. So it says he has to conduct an inquiry. He has to provide an opportunity of being heard. Now, this opportunity of being heard is even before issuing the notice. So he has to issue a show cause notice. He has to give some time period. He has to then consider the reply of the assessee. Now, this I almost find hilarious that we expressly have to mention this as well, that he has to consider the reply of the assessee, which should naturally be his duty. But because to eliminate all and any kind of confusion, the legislation made sure that, okay, we have to expressly mention that he has to consider the reply of the assessee. So it cannot be a mechanical that he only takes a reply and never considers it. So if he has to give reasons, he has to consider the reply and then give his reasons, and then decide the matter. Whether a notice under 148 has to be issued or not, then he has to decide after that. Now, in this also, if we see, it says that conduct an inquiry, like Sir had stated, that prior approval of specified authority has to be taken for all the steps. He has to take, before conducting an inquiry, he has to take prior approval. Before providing any opportunity of being heard, before issuing of show cause notice, he has to take prior approval. Before deciding the matter and issuing the notice under 148, he has to again take the prior approval of the specified authority. So everywhere it says that he has to take prior approval of the specified authority. Now, again, in this, there are judicial precedents which say that this prior approval of specified authority This cannot be mechanical either. This was in the case of the Supreme Court in the case of Sahara India Lucknow versus CIT stated that the prior approval of the chief commissioner or the commissioner or any other specified authority, this is the first inbuilt protection to the assessee against arbitrary actions of the assessing officer. So the assessing officer has to get this approval to ensure that he does not act in an arbitrary way, that there is always some reasoning behind the way he acts. And the Supreme Court also stated that there has to be application of mind to the facts of the case. So every case has separate own facts, unique facts. So every case has to be studied, and mindless application cannot be there. They have to, prior approval has to be given with proper due consideration. So this increases these all provisions and additions, they increase the safeguard for the assessee, as they almost provide a pre-notice stage. So even before issuing a notice under 148, they are providing a pre-notice stage. So now what led to this controversy and how it happened is that the Parliament on 29 September 2020, they came out with the Taxation and Other Laws Relaxation and Amendment of Certain Provisions Act 2020. So this was because of COVID disruptions and because of proceedings could not be completed, notices could not be issued, assessees had problems in fulfilling their obligations. So they extended the timeline, and the timeline was extended till 31st of March 2021. So the Relaxation Act, it talks about proceedings, passing of any order, issuance of any notice, notifications, etc., and it extends the date till 31st of March 2021. So what happened is then after this, because of lockdowns and disruptions and the second wave of COVID, the CBDT came out with two more notifications. And what they did was they had the right to do that. They were given the authority to do that under this legislation. They extended the time period from 31st March to 30th June through two notifications. For one notification, they extended it till 30th of April. And by the second notification, they extended it further till 30th of June. So they extended this time period. And there was no controversy in that because they had the right to do so. They were given authority. What they did was in the notification, they added an explanation. So what they said in this explanation was that any notices for reassessment issued after 31st of March, the old provisions which have not been amended, which were now amended and which have now subsequently been changed and totally revamped after the Finance Act 2021, they said that we'll continue applying the old provisions. So in case you've got any notice after 31st of March, even though the procedure change ho gaya, even though that 148A has been added, additional safeguards have been added, everything has been changed, we'll still keep applying the old provisions. That's what they said in this explanation. And this is where the controversy began. That did the CBDT even have right to do this? They were specifically given authority to extend time. But did they have authority to pause the new amendments and keep extending the old amendments? So this is where the controversy began, and this is where litigation began. So assessees started filing writ petitions in the various high courts. And then they started challenging the two notifications that were issued by CBDT. The two notifications with this explanation. They contended that they had the right to extend the time. However, they could not have extended the application of the old provisions. They had to now, once they issue notices after 31st of March, now the new provisions have come into being. So they have to comply with the new provisions. So they have to comply with 148A. That is, they have to provide a pre-notice before issuing notice of reassessment under 148, sorry. And none of that had been complied with. All of these notices had been issued as per the old law. Now, this is where various writ petitions were filed, and what has been the court's view of this. So now the Delhi High Court in this now, and there have been writ petitions throughout the major high courts. And what has their finding been, and how have they reacted to it? So now the Delhi High Court has they heard they prima facie said that this notification is contrary to settled principle of statutory law. So they stated that once you got in a amendment, you change the procedural law totally. How can you continue applying the old provisions of law? And they continue to state that this is what the delegated legislation. They had time to they were given authority to extend the time, but they were never given the right to extend the old provisions of law. So they prima facie stated this, and this view has also been stated by many other high courts as well. So the Andhra High Court has also stated the same. Bombay High Court has done the same. Calcutta has done the same. Madras, Odisha, they've all taken the view, and what they've done is they've stayed these notices, and they've given the government an opportunity to explain their position. They've issued notice to the Attorney General, and they've given the government to come up with their explanation, and they've set a date. And what they are doing is that any writ petition that is being filed is being clubbed with the main writ petition. So in case any writ petition files, it gets clubbed with the same order. So same order is being passed in all the writ petitions now. And so there are various writ petitions which are filed almost every day, 15, 20, and all of them get clubbed together. A common order is passed, and they are clubbed on to the same date that they'll be decided. So for Delhi, like 28th of September has been what the court has decided the date. So before that, they've clearly stated they've given time to the government to reply, and they've given time to the SS to file their rejoinder as well. So they want all the paperwork to be completed before that, so that on 28th they can proceed with this matter, and there is no stalling. They've also, in subsequent orders, they've also stated that no more adjournments will be granted. So separate dates have been decided by separate high courts. Like Delhi is 28th September, Bombay has some other date. What they're doing is they're clubbing all these writ petitions together to be heard at a later date together. Now, the only anomaly in this is even the Andhra Pradesh High Court prima facie said that this is beyond the scope of powers that was ever given to you. You were never given the power to pause the new procedures and then continue issuing notice under the old procedures. The new procedures have so many safeguards for the assessee. The old provisions don't. And the only anomaly in this has been the Chhattisgarh High Court. The Chhattisgarh High Court stated that because of these, the Relaxation Act and the time period which has been given, the assessee got benefit of that. So why shouldn't the department also get benefit of that? So they stated that they do not feel that there is any issue with this. They dismissed these writ petitions, which is the only high court which has looked at this separately from all other high courts. And this was a single judge bench decision. So it is likely that they might go into a patent appeal into this. So, but other than that, all high courts have all had the similar view. Now, it's what do we think will the future of this be? How will this issue eventually be resolved? It's hard to speculate how it will go, but it is possible that the courts might quash if let's say the courts have because prima facie they've said that okay, we feel that this is illegal. These notices after 31st of March following the old provisions are illegal. So it is possible that they might quash all these notices and give the department an authority to issue these notices again once they comply with the new provisions. So once they comply with the new provision, then they can go forward with this. And that is for only matters and for notices which are not time barred. And but this still puts the assessee in a good position because it still guarantees him more safeguards than the earlier provisions. So it gives him that pre-notice right, where he gets a pre-notice and he has a chance to explain himself before getting a notice of reassessment under 148. If the courts decide this, I feel this is what is possible. It is also possible that because now we see that the Chhattisgarh High Court came up with a different view, it is also possible that all the high courts might decide to refer the matter to the Supreme Court so that the matter can be resolved at once. Because it is very likely that other high courts might have a different view from some other high court, which will only further litigation, which will only further the controversy, and it will just become a bigger mess than it is right now. So it is possible that the high court issues, a high court gives the Supreme Court either takes suo motu cognizance or a high court refers it to the Supreme Court. It's very much possible that this is the view that is taken. The third, obviously, is possible that the government steps in. Now, it is unlikely to say when the government would step in. Will they wait for the decisions of the High Court? Will they step in with the ordinance before that? And it is hard to say when the government would do that, but they might come in before with a ordinance and with a notification to clarify how to proceed with these notices, which have been issued after 31st of March 2021. So right now, I feel that for an assessee who has received a notice after 31st of March, the best way to go about is to file a writ. At least you can get your note. At least you can get that notice stayed. No action in that notice will be taken against you, rather than ignoring it or waiting for or replying to it or any of that. It's better that they file a writ in the respective high court. And as long as it's not Chhattisgarh, because we see that Chhattisgarh is dismissing those writs. So all other major high courts have been admitting those writs, staying those notices. So I feel that is the right way to go for any assessee at a personal level, that if they have received any notices after 31st of March 2021, to file a writ in the respective court, get it stayed, and then patiently wait and see how this controversy unfolds, how the courts react to it, or how the government has eventually steps in and brings about an end to this controversy. So for now, we have to be as patient, and in case we have received any notice after 31st of March, it's best to just file a writ petition. And with that, I would like to conclude my presentation, and I hope I was able to bring some clarity to this controversy. Thank you.
Thank you so much, CA Sunil Arora ji and CA Devrat Arora ji.
No, I'm an advocate.
Okay. So, sir, thank you so much for such a wonderful session. Like it was really informational. And I don't think there's any room left for any questions after such a informational session, because till now we haven't received any queries. But sir, based on the number of participants here, so I have a few questions just to make the session a bit interactive. So, sir, the first issue is, like earlier, the bank statements were also considered as books of accounts for the purpose of recording reasons to believe. So now, in case the assessment is being reopened under Section 148, in the cases where a period of 3 years have elapsed, in that case, would the AO have the benefit of considering the bank statements as books of accounts and then recording the reason that he has information and books of accounts available on record, and he has reasons to believe that income has escaped assessment?
Okay, now let me try and answer this. First of all, reasons to believe is not required now. So what is required is that the assessing officer should have information which suggests that the income has escaped assessment. Now, bank account or my transactions in the bank is definitely an information based on which which can suggest that the income has escaped assessment. This is obviously subject to inquiry, which is provided under Section 148A, subject to clarifications. There can be a case, like you can take an example. Let's suppose an assessee has shown a turnover of 2 crores in his books of accounts. That means his financial statements are showing a turnover of rupees 2 crores. And keeping in view the size of the balance sheet, there are no loans, there is no other transaction reflected in his balance sheet. And you find that his bank accounts contain a cash deposit of 10 crores. I'm just giving you an example. Now, this is an information which would definitely get flagged as far as RSM is concerned, RMS is concerned, that is risk management strategy. And as a result of which, the assessing officer can conduct an inquiry, seek an explanation from the assessee, and thereafter take a call whether reassessment proceedings should be initiated, 148 has to be issued or not. So bank accounts, you are distinguishing between bank accounts being books of accounts or being a bank statement being an... Now here bank statements, even deposits in the bank account have been taken to be an asset. That means if there are deposits in your bank account, they would be considered as an asset, and based on which the time frame which is available to the assessing officer can go up to 10 years from the end of the assessment year. So he can initiate on this basis, he can initiate the reassessment proceedings. So definitely bank information, bank statements and bank information is going to be a very vital for the purpose of initiating. And here it is not important whether this is books of accounts or not, because this has got no relevance right now. So it need not be books of accounts, because that is more relevant when we talk of 69B and all other sections which are there. But then here, as far as for the purpose of this is concerned, reassessment proceedings, bank accounts definitely can be an asset deposit in the bank account based on which reassessment proceedings can be initiated.
So, sir, in short, the assessing officer has a grace period of 4 years now. In addition to the 6 years earlier, now he has a period of 10 years to reassess the entire case.
Look, the thing is that earlier, he had 4, 6, and 16. Now, 6 was the approval only from PCIT, and what he could do was that where the income which has escaped assessment is more than 1 lakh rupees, he could go up to 6 years. There was only one restriction there, which was there. That means if the assessee has filed his return, made full and true disclosure, and the income of the assessee has been assessed under section 143(3), then the assessing officer could not go beyond 6 years, beyond 4 years in that particular case. So that means the assessing officer could not go to even 6 years in that situation. That was under the old law. Now what has been done is that 4 years has been reduced to 3 years in a way. But then the other limb has been increased. That means clause B has been increased to 6 to 10 years. But when we talk of clause B says, clause B has a little restricted application. That means the income which has escaped assessment is in the form of asset. The income represented in the form of an asset has escaped assessment, and it should be more than 50 lakh rupees. That means beyond 3 years, all cases of less than 50 lakh rupees would be out of the ambit of reassessment. This is one. Second thing, what is going to happen is that at least cases which are not reflected, which are not in the form of assets which have not been disclosed, would also be outside the ambit of this reassessment proceedings. So in my opinion, that if it is a situation where I've been disclosing my income, and I have disclosed an asset which I had formed, or which I had all my assets are disclosed. In that particular case, the period of 10 years would become redundant in that case. So it would be, in some cases, yes, the period has increased from 6 years to 10 years. But by and large, in most of the cases, you will find that the period for which reassessment proceedings can be initiated has come down from 6 years to 3 years, by and large. But then, yes, some exceptions will be there where it will go up to 10 years.
Okay, so, sir, the next question is, like earlier, the mechanism used, it was that the AO used to issue the notice under section 133(6) for conducting a preliminary inquiry. And based on the reasons recorded, he used to reopen the case under section 148. But, sir, as per the latest provision, he has to record the reasons under section 148A and then reopen the case under 148. So, sir, how is the mechanism different from the older one?
Now, a mechanism is different in the sense that there were instances earlier where the assessing officer used to get some information from, say, a DG investigation or from any other branch of the department. Based on that particular thing, he internally used to record the reasons to believe, take an approval, issue straight away 148. I mean, this is what he used to do earlier. And what used to happen was in such situations was that once 148 has been issued, you are under an obligation to file your income tax return. The GK and Drive Shaft also provided for this, that you file your income tax return. Then we used to request the assessing officer to provide us with the reasons to believe. Now, based on those reasons to believe, we used to file our objections to that. Now, objections were to be disposed of by passing a speaking order. Now, this was not provided under the law. This is what the law was pronounced by the Supreme Court in the case of GK and Drive Shaft. Now, most of the officers were not following this particular procedure. So they were not familiar with the orders of Honorable Supreme Court in the case of GK and Drive Shaft. And what they used to do was that I file my return, they should initiate 143.2 and start assessment proceedings. If I have filed a request for giving me the reasons to believe, at times they even forgot to give me the reasons to believe. So now what is happening in those cases was that I let the assessment happen. My assessment has happened. I go before CIT appeal. I raise objection that my reassessment is invalid. I was not given the reasons to believe. I could not file my objections. Now, what used to happen was that tribunal or high courts in a number of cases struck down the reassessment proceedings that the reasons to believe were not provided to the SSC. And so he could not have filed his objections to that. The objection, if I filed the objection, the assessing officer did not pass a speaking order. As a result of it, what happened was the reassessment proceedings were struck down. So now this is more like educating the departmental officers to follow a certain procedure and to crystallize it so that there is no, because the problem with the department was, as I said initially also, the problem with the department was that their number of reassessment proceedings were getting struck down by various courts. So they wanted to eliminate that, and they wanted to put it in clarity as to what is the law with respect to reassessment. So that is why this law has been legislated. So they have tried to put everything together there. That is the thing. So the assessing officer also knows there would be litigation. As I think Mr. Devra has already talked about it, there's so much litigation right now. But then the new provision, this is up to a certain extension which is there. This is right now the litigation is up to that. But then, yes, there would be litigation. But to my mind, the manner in which the law has been legislated now, the manner in which reassessment proceedings have been brought into the statute now, to my mind, it should reduce litigation, because this seems to be looking quite clear as to, except for there be few issues, what is the information which is suggesting, was the information suggesting or not. So there would be issues. I'm not saying that entirely there will be no litigation, but then by and large, yes. The intent of the department was to crystallize everything with clarity to the departmental officers as well as for the court subsequently, and to ensure that the litigation can be reduced.
So the next question is, whether two parallel reassessment proceedings can be conducted at the same time?
Now, as far as repetitive reassessment proceedings are concerned, this can definitely be done. Now, in the sense that if I was issued one notice under Section 148 after passing the procedure, second information comes to the department, to the assessing officer, that there is another income which has escaped assessment. Now, let us understand the law. The law says that if any reassessment proceedings have been initiated against me, if during the course of this reassessment, if the assessing officer comes across any other income which has escaped assessment, he can assess that income also as during the course of reassessment. So now, let's suppose that during the course of my assessment which is going on, the assessing officer comes to know of some other income which income has escaped assessment. Now, the new law specifically provides that the assessing officer need not comply with the provisions of Section 148A. He can assess that particular income also as a part of my reassessment proceedings. This is what the law now provides. It used to provide earlier also, post-amendment which was made. But now it is provided that he can assess that particular income. Now, let's suppose he completes my assessment. After completing my assessment, reassessment also he has completed. He comes across another information that my income has still escaped assessment. There is some more income which has escaped assessment. So to my mind, yes, there there is no bar on initiating a reassessment proceedings again against me. It is not a final assessment. In the sense, reassessment is for assessing an income which has escaped assessment. Let's suppose, in my case, what happens is that I file my return. After 2 years, the assessing officer finds, like following the same example, assessing officer finds that I have a deposit of 10 crore rupees in my bank account, whereas my turnover is only 2 crores. He can initiate reassessment proceeding against me. So he has the bank information. Based on that bank information, he concludes that yes, my income has escaped assessment. He makes an addition of, say, 8 crores in my returned income. Now he completes my assessment. Let's suppose there is a search subsequently after 3 years in my premises, and the assessing officer finds that I have an asset which was not disclosed to the department. I had purchased an asset totally out of my unaccounted means. Now here, the entire process of assessment in the search cases, there is a deeming fiction that income has escaped assessment during the last 3 preceding financial years. There is a deeming fiction which has been introduced now. And because my asset has been found, which suppose was 7 years old asset, so then the department is at liberty to initiate reassessment proceedings with respect to that particular asset which the department has come across now. So the department can definitely do that. But then, yes, to my mind, 2 parallel provisions, 2 parallel assessments cannot go on. I mean, in the sense that if my one reassessment proceedings are going on, so either the additional information should be clubbed with that particular information in reassessment and should be assessed together, or this reassessment proceeding should be concluded first and then a reassessment should be initiated against me. So it cannot be that 148 has been issued to me and another 148 is issued to me and 2 separate reassessment proceedings are going on against me. That would not be the correct interpretation of law to my mind.
So what would be the legal recourse available in such a case? Would the second notice be treated as non-est? In case the first notice is issued on 25th of March and the second is issued on 28th of March. And let's say during the period, the first notice gets disposed of by the assessing officer and he makes the addition in the second notice, which was issued on 28th of March. In that case, like in case the assessee prefers an appeal before the...
No, I think, Puneetji, I think what you're talking of is probably seems to be a case where, 2 notices have been issued for the same...
same assessee, same assessment year.
Same assessment year
but different bank accounts.
Or is it by 2 different jurisdictions? It would probably be a case either 2 different assessing officers have taken up the jurisdiction of one. There is a jurisdiction problem there, or by mistake 2 notices have been issued. It is not based on 2 separate informations that 2 assessments are taking place. Now here, as far as 148 is concerned, there is no procedure for appeal against 148. So against 148, you only have the writ mechanism is available. You can go to the High Court for getting a 148 quashed. So I think you can take help from a lawyer. Mr. Dev is here right now. So now what you can do is you can, against the second notice, you can file a writ that I've already received a notice under section 148. Even before these reassessment proceedings have been initiated, another 148 has been issued. So probably the second notice should be struck down because once there is already a notice, so you can't have 2 notices for 148. So there is either a jurisdictional problem here or there is.
But he's saying the second notice is for a different bank account. So the subject matter is
I didn't hear that. Is it for a separate bank account?
Yes. So sir, the situation is the assessee has 2 bank accounts. The assessee receives the first notice stating that he has made cash deposits in bank account A.
Okay.
And the assessment is reopened on 25th of March. And then he receives a subsequent notice on 28th of March stating that he has also made bank deposits in bank account B. So the deposits in bank account A, the suitable replies were given and the proceedings were dropped.
So to my mind, the assessing officer, by the first notice which was issued, the assessing officer could have assessed both the bank accounts there. So he doesn't need a second reassessment proceedings. So even if you write this representation to the assessing officer, the second reassessment would be quashed. And I think he can club the 2 and proceed against the assessee against the first notice itself. He can initiate the reassessment because there is a built-in clause there The built-in clause is that if the assessing officer comes across any other income during the course of such reassessment, if he comes across any other income which has escaped assessment, he can assess that particular income also. Now, during the course of assessment, once it is going on, what is course of assessment and what is meant by that he comes to know? Now, the information was with respect to bank A. Now, the assessing officer, he can obtain the bank, he cannot make roving inquiries for other banks, but once he has information about bank B, so this is an information which he has during the course of this assessment. So he can always inquire about bank B in the first notice which he had issued, and he can make additions on account of bank B also there, which would be perfectly valid to my mind.
So these were the only questions. Thank you so much for giving your valuable time and educating the entire team here and all the participants who have joined us globally. So it has been a very informational session, and I believe all of us have gained a lot attending this particular session.
Thank you. Thank you, Puneet, for the good words.
Thank you, sir.
Yeah, and I was, because we are not able to see the audience, I mean, will it be telecast later? Because we are only seeing the Zoom participants who are here. And this is being telecast on some other, channel, or what is it? I mean, how do we telecast this?
Sir, the entire session is being telecasted live on the Icai TV. And there are thousands of participants watching it right now. So now I would like to invite the chairman of SR branch of NIRC of ICAI, CA Bharat Jain ji, for formal vote of thanks for the session number 1. Over to you, Bharat ji.
Thank you, Puneet ji, Mr. Devrat ji, and Sunil ji. मैं आप दोनों का धन्यवाद देना चाहूँगा कि आपने आपके बिजी शेड्यूल में से सीपी कमेटी के लिए और मतलब हिसार ब्रांच जो प्रोग्राम करी उसके लिए टाइम निकाला, और इसमें हिसार ब्रांच के मेंबर्स और बाहर के मेंबर्स को आपने एनलाइटन किया। और सर, आपका टॉपिक 148 के ऊपर एक मतलब जुगलबंदी की तरह हो गया। ये अच्छा लगा कि दो स्पीकर मतलब एक टॉपिक पे बात कर रहे हैं और एक नया कंसेप्ट सीखने को मिला ब्रांच को, और हम आगे से मतलब ब्रांच में भी इसको इम्प्लीमेंट करेंगे कि ऐसे सेशन हम करवाएं। थैंक यू सर, थैंक यू वेरी मच।
थैंक यू, थैंक यू,
थैंक यू।
So, Bharat ji, I would also like you to introduce our second eminent speaker for the evening, CA Abhishek Raja ji, who shall deliberate on the latest changes in the procedures in GST and the latest case laws.
थैंक यू पुनीत जी। अभिषेक जी, सबसे पहले आपका स्वागत करता हूं मैं आज ब्रांच के प्रोग्राम में। ही इज अ फेलो मेंबर ऑफ ICI, qualified in 2006 and hold master degree in commerce. He has more than 15 years of experience in the field of litigation in indirect tax, therefore VAT, excise and others. He is also speaker on VAT, GST, and deliberated many programs and seminars on the various issues. He has authored many books on GST, and his articles have been published in various magazines, websites, and various newspapers. He is also a radio and debate panelist. I welcome you, sir, on behalf of Hisar branch and CP committee. और आपके प्रोग्राम मैं हमेशा देखता रहता हूँ, और YouTube पे आपने जो भी इन टॉक किया था वो भी मैंने काफी सुना आपका, और बहुत अच्छा लगा सर आपको सुन के। मोस्ट वेलकम सर, वेलकम।
थैंक यू। First of all, I am very thankful to CPE committee and everyone here who has helped me and allowed me to speak and share my views. So we'll try my level best. So we will go one by one with the procedure, and next 45 minutes we would be discussing procedures, and next 45 minutes we would be taking care of the case laws. So we will discuss what all changes have been effective from 1st of January 2021. First was the blocking of GSTI. So Rule 138E was amended, and which said that if you have defaulted in filing of 2 of your return, then you would not be available. You would not be allowed to generate e-way bill. The catch in this was that even if your GSTIN has been suspended, then the other party could generate e-way-bill for you. Or say if you are a transporter, if your number is suspended, then the party sending goods could generate e-way-bill. So a recipient can generate if you are a supplier, or a transporter can also generate, or it could be otherwise also. This is the one method. So now, due to Corona COVID, this was relaxed to some extent. Now it has been forcefully set. And blocking of e-way-bill, blocking of e-way-bill. So earlier in e-way-bill, if you have multiple mode of transportation, so you were not allowed to add ships and road, both of them. Now it has been allowed. And as you all know that for multi-dimensional cargo or for ships, the time limit is different rather than what we have in normal scenario. So this is a very important change. This would help many of them because they were facing problems. And they have approached the government that when we do transportation through multiple modes, then it was a problem. The problem one which they have reduced the time limit for or the distance has been doubled. So earlier for 1 day, for every 100 kilometers, there used to be 1 day. Now for every 200 kilometers, 1 day limit is there. So this has impacted a lot. But again, as government says that due to better facilities and less checking and FASTag and radio FTG devices they are coming with, so then it is the right method. Now, this we have discussed again. So if you have not furnished return for 2 months or 2 quarters, then you will not be allowed to generate e-way-bill. Now, earlier we can submit a refund application for 1 year. Now it has been allowed that you can submit refund application for 2 years. Now, the limitation period, there was an issue, and they said that this will exclude from the date of filing to the date of deficiency. This would not be construed if you receive a deficiency memo. So when you file a refund application, either you get a acknowledgement number or you get a deficiency memo. So if you get a deficiency memo, then that period will be excluded. And if you have filed an application and you want to withdraw that refund application, so you can do it before issuance of a provisional refund sanction order or final refund sanction order or payment order RFD 05 or refund withhold order or notice for refund. So practically what has happened when you file a return, file an application for a refund, then you get a acknowledgement number or deficiency memo. Then you you remove the doubts or deficiencies. Once your deficiencies are removed, then from the original date of filing, within 60 days, you get some, within 60 days and 90 days, you get some X amount, and within 7 days, you get 90% of your refund amount. And then this has to be done for that 90% is in the cases of export houses. And in these cases that you can withdraw your application. So this withdrawal facility was not originally incorporated in GST, but this has been provided later on. And when you submit your application, you debit your amount from electronic rate ledger and the cash ledger. So in case you have debited that amount, so when you have withdrawn your refund claim, then the amount shall be reversed to your respective ledger. So if the amount was debited from your electronic credit ledger, then the amount will return to your credit ledger. Or if it has been debited from the cash ledger, then it will return to your cash ledger. So then this is in continuation of this. Now, department is facing problem of fake invoices. Every day you would come across a news that such X amount fake invoices racket had been busted or something like that. So last year, Department of Law, so the law committee of the GST Council, there are basically two committees, law committee and the second committee is which finalize the rate portion. So the law committee gave two strategy. One was that you should link this new registration with Aadhaar type, or you can go with biometric. And second, they said that you go with the physical verification. So considering this, Rule 8 and Rule 9 was amended, and Aadhaar biometric verification or Aadhaar authentication has been incorporated. So for old registrations, you would be getting option to link your registration with Aadhaar. And for new registration, either you link, it is mandatory now, either you link with Aadhaar or there would be physical verification. As you all know that GST registration was to be granted within 3 days. If within 3 days it was not granted, then it was deemed to be granted. So because of Aadhaar authentication, the deemed time period was increased from 3 days to 7 days. But in case none of the person is interested in getting themselves Aadhaar registered, or still Aadhaar is not mandatory, so someone might not have Aadhaar. In those cases, physical verification would be done, and then in those cases, registration would be completed within 30 days. Now, there was an issue with the revocation of cancellation of registration, and we got circular 148, and later on we got one more circular 152 on this. Sorry, 154 on this. So section 30, and it said that if your GST registration has been cancelled, then you have to apply within 30 days for revocation. Later on, what they said that 0 to 30 days with the appropriate officer, assessing officer, and 31 to 60 days time limit can be done by additional commissioner or the joint commissioner, and 61 to 90 days for commissioner. Due to Corona COVID, this limit has been doubled. So now it is 180 days. Plus the GST amnesty, which is going on along with the, now originally in this amnesty, there was no revocation facility, but now the revocation facility has been provided, and till the last date is 30th September, till which you can apply for revocation. And what would be the cases from where revocation can be filed? So these would be cases where GST registration would have been cancelled, and the application for revocation could have been filed from 1st March 2022, 31st August 2021. So these dates have been going on because of Corona pandemic. We had extended many time limits, and so an Honorable Supreme Court has also extended many time limits. Now there was a new insertion last year, the cancellation of the GST IN. So now in cases where you avail ITC exceeding the permissible limit, this could be cancelled. Or second, where your liability in GSTR 3B is less than liability in GSTR 1, then cancellation might be initiated. So then when we come in later slides, so this intimation should have been done by REG 31, but the software is not able to, so they are not able to create form GST REG 31. So still the notices for these are coming under in old form REG 17. The GST REG 17 has been used in alternative of GST REG 31. So now the problem is this: for example, if there is no revision option in GST returns, and there could be a genuine case where, say, we have shown correct figure in GSTR 3B. Say I had shown 1 lakh rupees sale in GST REG 3B. Mistakenly, I had shown 10 lakh figure in GSTR 1. Now, this could create a problem. Now, how we will be dealing with this, how intimation to the department should be done, So that is a different thing. But now they have amended the rule, and in these cases, your registration cancellation could be initiated. So now you're not allowed to file GSTR1 if you have missed 2 months this GSTR3B, and for quarterly filing if you are not paid for the previous period. Also, there are discussions with the Rule 86B. We will be taking it later on, where you can take maximum credit of 99%, and there are exceptions also in which cases you can avail 100% of the credit. Also, when we go across SOPs issued on 12th of May 2019 with respect to fake invoices and higher ITC limit, so in those cases, what they have said that the department would be using 360-degree analysis software with artificial intelligence, and wherever you avail credit more than 95%, so those cases would be intimated to the assessing officer, and assessing officer, after some sort of investigation, would proceed with the case, or he would close the case. So again, if you are availing more than 95% ITC every month during the year, then be sure that this would be intimated to the assessing officer with a red flag that these could be the cases where, due to higher availment, it could be indulged in fake ITC practices. So again, with Rule 86B, which has been implemented from 1st of January 2021, there are certain cases which cannot utilize more than 99% of the ITC, but there are exceptions also. We'll be taking care of. Now, the problem with this Rule 21A is that before using this, opportunity of being heard was there in the section, in the rule, and now this has been deleted. Now, for intimating a notice under blocking your credit under Rule 86A, now you are not now he is not required to intimate you. The department can block your ITC without intimation. Now that ITC would be blocked for maximum 1 year, and within that 1 year they have to do your assessment, and they have to issue you notice under section 73 or 74. But as this is a case of not bona fide intention, so this 86A would be used all in cases of mala fide intentions, then as per my opinion, notice under section 73 cannot be issued. Show cause notice will always come under section 74. So that is my personal opinion, considering all sections. Now the notice would be served for cancellation notice would be served under REG 31, and within 30 days you have to submit your reply, and during this period you are not allowed to make any supplies. So now this is a very important thing which Honorable Rajasthan High Court in recent judgment has said, that you should not suspend GST registration, because this is against a business policy, and you should be very cautious while suspending any registration, because during the period of suspension, one cannot do any sort of business activities. Practically, we might continue, but legally we are not permissible once our GST registration has been suspended. Once suspension is revoked, then only we can do business activity. There's one thing that they said, that if your GST registration has been suspended, that during this period you will not be allowed to file your refund application, or refund cannot be granted. That seems logical. So then these dates has been extended. So now when we come to when you file an application for revocation, then CBIC has laid down some manual procedure that how this application would be processed, how this application would be submitted. So now what they have provided that, well, I said that 30 days has been extended, 31 to 60 61 to 90 days. But in those cases, you will not approach the commissioner or a joint commissioner. So in those cases also, if you want, say, if there is a delay in filing application, then you want to condonation of the delay. So then application you have to submit with your assessing officer or the proper officer, and he will ensure that such application is forwarded to relevant JC, DC or the commissioner itself. So you will not directly approach to the commissioner. You will file your application for even for condonation to that will be condoned by the commissioner with your assessing officer or the professor officer, and he will en route go there. Now, if the application for condonation of delay is accepted, then opportunity of being heard is not mandatory. But in case they reject your application for condonation of delay, in those cases, before passing of rejection order, they have to give you a personal hearing. So in this case, principles of natural justice has been upheld, but otherwise, with respect to it is Rule 86A, Rule 21A, Rule 86B, so we don't have principles of natural justice. So in those all three rules, principles of natural justice has been deleted, but in this case, principles of natural justice has been incorporated itself. So then we got a cancellation of a voluntary registration, which was not provided from the start of this, and this is so when restrictions of the claim from November 2019, so then GST ITC was restricted to maximum 120%, 100 plus 20% over and above what is available in your 2A, subject to restrictions of 17.5 or 16 subsection 4. Then later on, from February 2020, this was restricted to 110%. 20% was restricted to 10%, so 110%. Because of Corona COVID, so from February 2020 to August 2020, this was relaxed, and cumulative impact of every of this 10% limit was to be given in September 2020 return. Filed in October 2020, and from 1st of January 2021, this limit has been restricted to 5%. So then 20, then so from November 2019 to January 2020, it was 120%, 100 plus 20%. Feb to December 2020, 110%. Subject to that, from Feb to August, this position was relaxed. Cumulative impact September, and from 1st of January, now it is 100%. So now the issue comes that we have two forms, 2A and 2B. So 2B is for eligibility and 2A is for the quantification. So quantity or amount has to be cross-checked with respect to 2A, and the eligibility has to be cross-checked with the 2B form. So because we might get credits which are not available as per 16.4 restrictions. So then this is in continuation of this. So then we have this rule 86B, which came on 23rd December, or say, if I'm not wrong, 22nd or 23rd December 2020, this notification came. So this has incorporated a new rule where you can maximum utilize in a month 99% of the ITC for your taxable outputs, subject to that your monthly turnover exceeds 50 lakh rupees. So what are the exceptions on which this rule would not work? So if the taxpayer has paid more than 1 lakh rupees income tax in preceding 2 financial year, or where the taxpayer has received more than 1 lakh rupees of refund from CGST Act, then these sections will, so this rule would be relaxed for them. Or where the person which we are discussing, relevant person is a government department, public sector undertaking, local authority, or statutory body. So these are the exceptions. So in case of an individual the proprietor, 1 lakh rupees would be checked of the taxpayer. In case of HUF, 1 lakh rupees could have been paid by the Karta. For in case of company, it would be managing director, whole-time director. In case of a partnership firm, it would be 2 partners. So this is a long list, and we have to cross-check. It would keep on changing with the entity structure. Now, other than this also, now government has said that in case you feel that you are a genuine case and you have to utilize more than 99%, then you can approach the officer authorized by the commissioner or the commissioner, who can provide you relaxation from this rule. The problem is that government is yet to announce standard operating procedure for this relaxation. So what we understand, that view of a commissioner sitting in say in Jammu and Kashmir would be different than views for the one who is sitting in Tamil Nadu or Kerala. Now the situation would be very different. The work culture would be very different. Therefore, government should come with some sort of clarification on this, so that so this would remove jurisdictional view, or a person ideology might restrict some cases, or personal views might restrict. So this could be a suggestion from my side, that government should come how they have to deal with applications received in such cases. Then now they have restricted that if a person is under composition scheme for service provider, then he is not allowed to engage in providing exempt services. He would not be allowed to provide interstate outward supply of services. Also, he would not be allowed to provide services or engage in services where supplies have been done through electronic commerce operator, ECO, because ECO would be required to collect TCS from the party, vis-a-vis a service provider in composition scheme would be paying a specific amount, and therefore these 3 things have been restricted. So ideally these 3 should have been restricted initially itself when they came with the composition scheme for supplier of services, but and for the supplier of goods, now they are permitted for maximum 10% of supply of services, but again they are not permitted to supply exempt services on the supply of services on which tax is not payable, or interstate services, or through e-commerce operator. Similar provisions have been come for TDS provisions also. Now, this is a major change. So, for example, an invoice was generated in 1718. Now, say we charge a different rate. We charge incorrect rate for that. For example, we charge 12% rate on that. And now after 2 years, we are correcting it. And now we are issuing a debit note for say 18%. So differential of 6% of the tax has been charged. Or for say we are levying interest on the delayed payment. Now, before this amendment, to be very honest, my initial view was that credit for debit note would work from the date of debit note. It could not be linked with the date of invoice, but the amendment is like this. Now it has to be linked with the date of invoice, and therefore, if section 16 subsection 4 plays its role of non-allowability of the credit, which we understand that section 16 subsection 4 says that your credit would be allowed before you can claim credit before filing of your September return of the next financial year, which has to be filed in October, or filing of your annual return, whichever is earlier. And And as we all know that GST annual returns are being delayed, so therefore September returns become crucial. So we had a discussion of AAP and Company, in which Honorable Gujarat High Court had said that GSTR 3B is not returned and therefore it could not be linked. So then government has approached Honorable Supreme Court and they have got a stay on this order. So sorry, they have amended retrospectively, they have amended the law. Therefore, ITC credits are linked with September GSTR 3B filing or annual return, whichever is the lead. So then they have got power that they can provide benefit for and then they can provide benefit who can issue invoices in larger time, more time. And TDS certificate, because there were detailed rules came, therefore the provisions of the act has been moved to rules. And this was this is a litigated issue since start of the GST. The department usually try to charge interest rate on the gross liability, whereas the assessee always contend that my net tax liability, and therefore the interest should be charged on my net tax liability, whatever I have to discharge in cash. So if I have a liability of 100 rupees and I have 80 rupees ITC with me, then my net cash liability, my net tax liability would be 20 rupees, and you should charge interest on 20 rupees only. So department in 2020 September issued a press release also, and the press release was not binding on the assessing officer. Assessing officers also press release was not valid for state officers. Therefore, they came with amendment in Fiscal Act 2021, where they have said that interest will be charged only on the net liability, except the cases where show cause notice would be issued under Section 73 and 70. 73 is for bona fide mistakes, 74 is for the mala fide mistakes. We should not say mistakes, 74 is for mala fide intentions and crime. So then now with this amendment, they have unsettled the already settled principles. So then the settled principle in the law was that you need two separate persons to make it a supply. A transaction between two means same persons cannot be construed as supply. But again, with this amendment, they are trying to, this is a very powerful amendment. Section 7(1) AA has been inserted, which says that if that it would be deemed it would be deeming function of that these two persons are two different persons for supply of goods. Now let's understand what were the law positions, and with this single amendment, they have what we can say they have tried to unsettle many settled judgment. So let's understand that this was judgment for West Bengal VAT, Kolkata Club. It was 2016 when this judgment was delivered, and it said that then in a club scenario, the members of the club and clubs are not to be considered two different entities, and doctrine of mutuality will come to play, and therefore if someone is club is supplying something to their permanent member, then it should not be charged to tax. So this was the decision, and later on it was challenged by the state department in the Supreme Court, and Supreme Court then went to the larger bench of the Supreme Court, and they said that in these cases, Constitution of India doesn't allow to levy taxes whether the clubs are incorporated or unincorporated for supply of food or drink to their permanent member. And this decision becomes very important, that this decision came after the Article 366 was amended by 46 Constitution Amendment. So Constitution says, sale tax says that should not be there. And then they came with the amendment in service tax laws also. And in service tax laws also, the decision came against the department, which said that you cannot demand service tax from members of the club. And they said that even after amendment, so in this case, Honorable Supreme Court larger bench said that even after amendment to Constitution, whatever you are doing, you are not allowed to charge neither service tax from the members, nor you are allowed to charge sale tax from the supply of food centering to the members. And then AAR and AAAR of Maharashtra, there are two decisions in this. So in AAAR, Maharashtra Rotary Club of Mumbai Queen's Necklace said that activity of these would not come under scope of supply, and Section 1 doesn't apply, and this is not to be charged to GST. And same thing was said for the Nariman point. It was AAR, which said that it would not come under scope of supply. So see, so many amendments I am telling you, so many case laws, AAR Maharashtra, AAAR Maharashtra, these are two different cases. And judgment of Honorable High Court, judgment of Honorable Supreme Court, and Supreme Court also, the larger bench said that even after amending the Constitution, you are not allowed to charge tax. And this was a settled principle, and then all of a sudden, with this fiscal budget finance act, now the settled principle has been unsettled. Don't know how one should consider this. What to do. And so then we are into webinars. Earlier we used to have seminars. We are into webinars because of Corona pandemic. And because Corona pandemic was at its peak in the second wave in April and May, so therefore there was pressure from WHO or others for some reduction of GST on some things. So on DEC tablet, GST was reduced from 12% to 5%. And so for this tablet, it was request came from World Health Organization. For others, there was some trip integration, and these all, it was reduced, GST was reduced. And then in the last GST Council meeting, so they provided a benefit for educational institute, including the Anganwadi one, whereby servicing of food for midday meal, these would be exempt from this supply would be exempt, whether it comes from government grants or it comes from corporate donation. Similarly, fee is charged by the examination board, Nation Board of Examination, and such education board for these. So this fees has been exempt. Now the problem currently which is going on, that doctors are having an issue. So now they are having some equivalent examination that doesn't come under this NBE, and GST would be charged on those entrance exams. Now they have they have submitted their request many times. Doctors are requesting government, but again, their exams is not. Now this was for the land owners and promoters for utilization of GST. So now government has said that they should amend the law, and they should, how they will come with it, I have no idea. For this, I will explain in the next slide what is the problem, what problem they are facing. So, and then we have maintenance and repair overhaul units. So now the problem was that for Indian one, the rate was of 18%. For exempt one, it was rate 5%. So now they have combined both of the rates, and it would be 5%. So let's understand what's the problem with the landowner and promoters, how this happens. So for example, So it's a Hisar. I'm talking at Hisar one. So, for example, someone approaches someone. So builder approaches a landowner at Hisar, and he says, "Okay, I want to create a mall here, world's Asia's biggest mall." And he approaches someone. He says, "Okay, please provide me your land." So he has. So the person owning the land has 500 acres of land. He says, "Okay, give me your land." So he wants to purchase that land, but he doesn't have so much of money. What he says that, "Okay, I don't have money. Please provide me development rights. On that development right, I will do construction. And because I don't have money, I will not pay you in cash. I will pay you money through whatever I'm creating. For say, if someone is creating a commercial mall with 1,000 shops, so he says, "Okay, give me development right. I will give you 400 shops out of 1,000 which I build." So now this land development right, transfer of land development right. So government has fixed this under RCM, because the landowner is an individual, and the builder, they thought that he would be a corporate one or more registered one. So in those cases, when land development right would be transferred to a builder, so then GST would be paid by the builder on RCM. Now, the problem was that when he purchased land development right, so he was required to pay GST on it. Then the builder lobby approached to the government. They said that we don't have money. That's why we are not outrightly buying the land. We are short of funds. We are deferring their payment. We are not making them payment in cash. We are making them payment through, say, in this example, 400 shops we are giving them, 400 units we are giving them. So the government said, "Okay, whenever you transfer them, please to understand, whenever you transfer them this 400 units, then you pay GST to me." It's an RCM. So builder develops a commercial complex, and when they are completed, so then he transfers those units to the landowner, and then he makes payment to the government. Now, in this whole process, if the person has made some partial payment, say for example, that the final order price was, "You will provide me 400 units and you will provide me 10 crore rupees. Say 5 crore rupees the day when we signed the agreement, 3 crore rupees XYZ date, and 2 crore rupees on YZ date. Then whenever they are paying in cash, so then when they were paying 5 crore rupees in cash, so that day he has to pay GST to the government. And when he was transferring those units, 400 units, then on that day he would be transferring them, paying to the government. Now the problem arises. What is the problem in this? So the landowner who got 400 units as per the contract terms, now when these units were transferred to the landowner, so they were completed units. And when you are transferring completed units, and when the person who was before getting these units, he has an agreement and he would have sold some units. And as you all know, before completion certificate, if you receive some sort of advance, then whole of the amount is chargeable to GST. So the problem in this case was, landowner was having received GST amount, he will pay GST, but because units were transferred after this registration, so then when he get ITC in his credit, then he was not able to utilize that ITC for making that output payment. Therefore, this is an ambiguity with respect to landowner, because he transferred development right, he receives unit, he supplies that unit, he makes payment of the GST, but he is not allowed to utilize that GST. So then government has accepted, yes, there is a problem and they would be working on it. So the law committee, there are two committees, law committee and the fitment committee. Fitment committee discuss only the rate and the classification. Law committees refers the issues and helps in creating law, rules, regulation, whatever you consider. So then this matter has been referred by the GST Council to the law committee, and I hope they would come with some sort of finalization on this. And then if someone is applying to PDS, then there would be lesser rate. And for the NUT, we have been discussing on this. So normally you would be seeing much sort of write-up for this NUT and construction. So government has clarified that there would be exemption in these cases. So rope pay would attract 18%. So then they came with amnesty. They announced an amnesty and they said that the maximum penalty would be 500 rupees, 250, 250, where you don't have a tax liability. And if you have a tax liability, then maximum would be 1,000 during amnesty. And if you remember the last year amnesty, which ended on 30th September, for nil return, it was zero late fees. And for future period also, this has been reduced. And this was initially for 30th, so 31st of August. Now it has been extended to November. So now what they have said that, let's come this here. So if you have a nil return, then late fees has been rationalized. The maximum late fees would be 250 plus 250 for the future incidents. It would be maximum 500. If you have, so before this amendment, so there was a daily amount and maximum was the 10,000 amount. So now they have come that nil return, so more than nil return, other than nil return, and the maximum turnover is 1.5 crore, then the maximum penalty would be 2,000, 1,000 plus 1,000. 1.5 crore to 5 crore, if your turnover is, then it would be 5,000 rupees. And if your turnover exceeds 5,000, then the maximum penalty would be 10,000. Now the thing is that on the practical front, now they talk about GSTR 3B and GSTR 1 penalty, but practically what I have seen that penalties for GSTR 3B are levied through system, but penalties for GSTR 1 is not charged, or the late fees are not charged. I think for the previous period also, they would come and check this in, say, assessment. And return for maximum late fees for composition of teachers has also been reduced. And so then the date for extended because of Corona COVID. And now they have extended the option for using OTP instead of DSC for companies. So then rates were reduced for certain periods. Shall leave this. So then on some items, IGST was reduced. And in some cases, IGST was removed, or on the custom duties were removed, and then these are the rates. And then recently on 29th of August, GST late fees amnesty scheme has been extended from 31st August, which was the last date, to 30th of November. And now for 1 month, almost 1 month, they have provided revocation also, which they didn't provided initially, which was available in the 2020 amnesty, but this was not provided in 2021 amnesty. Now this has been rectified. And if your revocation application would have fallen 1st of March 2020 to 31st August, then you can apply for revocation up till 30th September 2021. And they are saying that I filed when if you would move it here. You can complete. So let's discuss some of the cases. Now let's discuss some of the cases. Otherwise, you will not be able to complete it. So what has happened in this case? There was a truck was going from transport was going from Kolkata and would have to be delivered in Agartala. Mistakenly, due to cracker error, it was mentioned as picked from Agartala, so Havra to Agartala, and it was showing 470 kilometer instead of actual distance of 1470. Now, this was a human error which picked incorrect address, and because of 1470 and 470, which was similar to them, these sent the goods, and goods were checked at the cargo. So the truck was intercepted at Tripura border, and memo for detention was issued, and now they detained the goods, and then aggrieved party went to Tripura High Court, and Tripura High Court said that maximum, at best, you could have levied a penalty of 5,000 or 1,000 for this minor oversight and a clerical error, because it was solely because of incorrect distance which has been picked, and other things were correct in the invoice. Other things were correct. Say party name was correct. Everything was correct except for picking up this wrong destination, and it should be construed as a minor oversight rather than penalizing the party. So in this case, government's honorable Tripura High Court said the maximum penalty 500 or 1,000 should be. Now, as I was discussing 86A, Rule 86A, and Rule 86A comes with the blocking of your electronic trade ledger, and this rule doesn't have principles of natural justice. Now, so before blocking your ITC, commissioner has to record reasons for blocking it, and maximum it can be blocked for 1 year, and during that 1 year, assessment has to be completed under section 73 or 74. Notice should be issued, and what I believe notice should come under section 74. Now in this case, Aryan Trading versus Union of India, what has happened that commissioner utilized his power, blocked the credit, but blocking continued for more than 1 year. Now, as per this rule, blocking can be maximum for 1 year, and even after 1 year, the blocking continued, and the Arya Trading approached Honorable Karnataka High Court, and which set aside the original order, and they said that okay, 1 year you had 1 year, you didn't did the assessment, and therefore we are not allowing you to continue further for blocking of the credit. Now you can use another things or assessments. Now this was again a case of Rule 86A, Urbanized Developer India Private Limited. Again, this is from Karnataka High Court. This talks about Section 17 and Rule 86A. Now, what has happened? Assessee filed his return, which was late. So, assessee GSTR 3B for March was filed on 12th of March 2009. Along with late fees. Now, department served the assessee an advisory to deposit equivalent amount which he has availed as per the credit. because department said that your credit was not permissible under section 16 subsection 4. Later on, department informed the assessee on the email that his electronic credit ledger was blocked under rule 86. Now, against this email, original email, so then what was the advisory by the department? So assessee has submitted representations on 3rd of September 2020 and on 10th of September 2020 for authority to unblock the credit, but nothing. Assessee approached Honorable High Court to give direction to the authority for unblocking his credit. And Honorable High Court said that you should have acted, you should have called the person, listen his views. One-sided action is not permissible. And therefore, they gave the time of 6 weeks to complete all this. And see, this is one of the issues with the department, that even when you try to submit or you try to raise your voice against their wrongdoing, or you try to explain them your point of view, they are not ready to listen. So this is again a problem. But on the practical scenario, whenever there are issues, you should submit all sort of replies and you should try to approach to the department. Now, next case is of BMW India Financial. So now the problem was that BMW filed Trans 1 form, and it had a credit of 21 lakh. It filed the form. They have received the acknowledgement also, but they had mentioned a figure of 21 lakh for the credit. But when the form was processed in the GSC, so this was a problem with the software or the web portal itself. When the form was processed, so then it took away 00 figures. And they tried to amend it, they tried to utilize that credit, but it was not allowed. And it was technical glitch. Now, department, they approached the department. Department said, no, you are not correct. You have filed 00 form, so we will not provide you credit. They were not ready to accept that there was some technical issues or technical glitches due to which someone has filed a form of 21 lakh, and when they see the form which has been processed is of 00 figure. Therefore, when they approach High Court, the Honorable High Court said, yes, party is correct, and they directed the department to provide them credit of rupees 21 lakh, which was required in this case. Then the power to search, seizure, and inspection. Now, in this case of Himani International, this is the case of Honorable Gujarat High Court, and in this case, this was the search was conducted. Search was for continuous 2 days, and revenue authorities did physical violence and torture of the employee, and they even forced them to switch off CCTV cameras of the office premises so that they can be indulged in physical violence. And statement were on coercion, डरा धमका के उनसे कुछ भी बुलवा लिया, लिखवा लिया. So they were forced to sign without their will or wish, and this was noted on the punch witness also, and this with this, so then Himani intermediaries approached Honorable Gujarat High Court. They said that these kind of allegations are of harassment, coercion, threats. cannot continue. This is not the right method or right approach. And even the party was forced to transfer 2.68 crore and paid by DRC03. And the notice was issued. Later on, the department was unable to prove that this was a genuine case, and they deposited this willfully. And with such kind of allegations, so then they were requested to return that money unless they come with a total computation of that without assessment or completing the totality of the amount. Department should not collect this amount as an incursion. Then the next case is from Honorable Madras High Court. In this case, assessee filed GSTR1 from August to December, and he committed an error in reporting credit for outward and intra-state sale, and this was mistakenly reported as interstate sale. As a result, CGST SGST was reflected in IGST column. Later on, assessee noticed it, and he submitted a request for correction. So in this case, see, mistake was noticed by the assessee himself, and assessee request. Now the department said that there is no method that they can amend this. Now, this was a challenge. And as you all know that we don't have option for amending GSTR1 or GSTR3 in totality. We have to amend it in future period returns and through amendment, and that too that too we cannot amend as we thought of amending or revision option. So the Honorable Court said that yes, these errors are human error and it should be construed, and therefore they were allowed to refile those GSTR1 with correct distribution of IGST, SGST, and GST. And the authorities were directed to provide them an option for filed correct return. Now, in some of the cases, what has happened, no, I'm not discussing about this specific case. In some of the cases, when it has been proved that this has happened, the problem need amendment of your earlier returns, and when there are no options in GST portal, courts have decided in favor of the assessees, and also in some cases they have said that if the amendment is not possible through portal, then the department is directed to take manual returns. So please do appreciate the views of the court that in all such cases where the department raise their hand and say that this is not possible through the portal itself, then in all those cases, courts have taken the view in favor of the assessee and said that it's not required, you can file manual also. Now this was a reversal of ITC, and this was with respect to earlier law, and they have said that if this has been from the previous regime, then it would be accepted here. Now in this case, the question was how much proportionality ITC has to be reversed with respect to loss of inputs in manufacturing. So then those who have dealt in excise, they would remember that there used to be a concept of remission of duty for natural losses. And I think the rule was Rule 4A of, or Section 4A of Central Excise Act. So then that section has not been incorporated in this GST, and therefore this reversal is not to be done. So because see, Section Section 17, subsection 5 is of the block credit, and which states about losses, goods loss, but it never speaks about the losses which has to be done on the unnatural loss. It talks about loss which are not natural, abnormal losses. So when the loss is a normal loss, then 17 subsection 5 will not work. Then in this case, what has happened? This case was with respect to incorrect address. Now what has happened? A truck was intercepted and the head office supplied goods to branch office in Kerala as it was shown, but address was mentioned of the different branch. And in this case, they have asked for finalizing the order, and then they have said that, okay, this you can ask for bank guarantee. You can take bank guarantee, but immediately release the goods, because the problem is this, it is not a big mistake on that. This is a human error. So in one of the cases which went to Honorable Allahabad High Court, so he entered incorrect number. Truck number was incorrectly entered. So number was something like that. It was 78, and invariantly it was mentioned at 87, the last 2 digit of 4 digit. So then the Honorable High Court said in Allahabad High Court in that case, no, these are human errors. Someone might do some human error. These should not be forced, or for these things you should not detain goods. Similarly, in one case, what had happened that that was also from Allahabad High Court. So then accountant made 2 e-invoices, e-way bill. One was for Bihar and other was for other places. And mistakenly, he gave wrong envelope to both of the truck drivers. And one was intercepted and everything was correct, except he was not getting the e-way bill correct, though it was generated online and it was having all details. So then also in that case, Honorable Allahabad High Court said, no, we should not force such kind of thing because this is human error. So now, in this case, the issue was of validity of Rule 86A, which I have been discussing in these cases. Now, this was the case where investigation was not completed, inquiry was not completed, only there were allegations of fraudulent transactions. And they said that whether in those cases, without completion of, say, their inquiry, without completion of their investigation, whether they can block the ITC or not. So it was said, court order, that commissioner has assumed that that because letter sent by additional commissioner will help them, or it is conclusive evidence without calling or examination anything on record. What has happened? Additional commissioner wrote a letter to the commissioner that I feel this party is doing wrong, please block this credit. And without going into merit of the case, without actually cross-checking the evidence, without actually examining the record, the commissioner blocked the credit or gave the order for blocking of the credit. And the wordings of this case is very important. If you read, the court said that this order was issued by the commissioner without application of an independent mind. And this is a very, very judgment which is against someone, where someone is saying that you are not using independent mind, then unfortunately we saw this judgment, but the way things are progressing, we might see many more such judgments. So then this was the case of Honorable Uttarakhand High Court, where this was allowed, this was on the disallowing debit of electronic credit ledger. So this was a manufacturing unit in Haridwar, and it was trading, and it was, his ITC was blocked under Rule 86A, stating that they have availed ITC of 1.5 crore based on the fake invoices from non-existing firm. So then the issue in this was that without going into merit, without checking all details, the department blocked credit. And the credit block should be for maximum 1 year. Vis-a-vis, they didn't open it. It was blocked on 15th of January 2020. And ideally, all proceedings under section 73, 74 or assessment should have been completed by 14th of January 2021, which constitutes 1 year. But it was not done, and it was continued beyond 1 year. So then, in this case, court said that this has to be unblocked, because blocking of credit more than 1 year under Rule 86A is not permissible. Within this year, you have to complete your assessment process. So now this is again a different case where a raid was held on an assessee, and in this case, while seizing everything, they seized cash which was found in which was found in the premises. Now the question or the issue in this case was, when we read about the definition that this can be the things can be seized by the department or confiscated. Now, whether money is a thing or money is covered under thing or not, and in this case, court said yes. Yes, and money is part of thing, and if officer feels, then they can seize the cash also. So then, in this case, this was the case where bank account of other person other than the taxable person was blocked. So then, in this case, this bank account was of a director. This bank account was blocked of the director. So then the court said, no, you cannot attach property of other person other than the taxable person. So if you want to block property or assets also of the taxable person, you can block for them, but you cannot block bank account of a director or advisor or someone else unless it is proved that they are directly linked in these kind of activities, or you want to lift the corporate veil. But blocking of bank account of third person was not allowed. So now in this case, there was investigation, and someone on the coercion of the department, he signed that yes, I have to pay this much amount, and such kind of coercion and such kind of threatening things which have been done by the department is not allowed. And before asking for the payment, before concluding the assessment or determining the final liability, all such amount collected is not correct. And even there is a problem in the GST law that in earlier regime we had an option of payment under protest, but now we don't have any option of payment under protest where we can pay taxes or we can pay amount under protest. And the worst thing which we can which is that FAQs by CBIC issued last year, which has specifically mentioned in one of the FAQs that whether you can pay any amount under protest in GST, and only one word they have written no. So this payment under protest is something which we had been seeing, which has been acceptable practice in so many years, which has been developed like anything. But now with one of the FAQs, the question could be whether with one FAQ, can they remove this age-long principles? I doubt. And then, no, this was then revival of registration and revocation. It was so, and they said that because they have it cannot be revived because they have incorrectly availed ITC. Now they said that your registration cannot be revived because you have taken incorrect ITC. And in this case, Honorable Madras High Court said that it would be putting cart before the horse. So then again, we had discussed one more case where the judgment has very bad words against the department. In this case also, the words were very bad against the officers which have done. And this is a very important case where Honorable Madras High Court had said that automatic reversal of ITC, which we understand through 2A, 2B, Rule 36, Sub-Rule 4, 20, 10, 5, or in future we might have real-time credits. So then, if you have got the reversal of the ITC, then what actions you are taking on the seller? Because see, default has been done by the seller. He has not paid the taxes. He has not supplied. He has made a supply, but he has not paid the taxes. So therefore, revenue authorities should trace those dealers, should work on collecting amount from them. And see, this is in this GST law, this Honorable Madras High Court decision. But again, the similar, if we talk about erstwhile indirect tax laws, then we also have such decisions. So, for example, in Gheru Lal, Honorable Punjab and Haryana High Court has said that you cannot ask the purchaser to run from post to pillar for proving their purchases. Similar was the decision in Shanti Kiran, name was incorrect, Shanti Kiran of Honorable Delhi High Court. The only thing, a reverse decision is there from Honorable Bombay High Court in Mahalakshmi Cotton Mills, where that Honorable Bombay High Court have said that when legislative fails, when executive fails, then power can be given to executive machinery to collect taxes, to safeguard the interest of the revenue. So if we go by 3 High Court decisions, so in Gheru Lal, it was in favor of the SSC. Shanti Kiran, it was Delhi High Court in favor of the SSC. Vis-a-vis Mahalakshmi Cotton Mills was in favor of the department. And later on, Gheru Lal and Shanti Kiran were upheld by Honorable Madras High Court in one of the editions. Name I am forgetting. So then there was this case, attachment proceedings on the to protect revenue in certain cases. Again, Honorable Madras High Court, they said that department has so many powers, but attaching everything is not the right way. And of course, this attaching properties and not allowing you to function or to do your business is again against the Article 19 of the Constitution, which speaks about right of practice any profession or carry any occupation or trade or business. So in this case, a cancellation or suspension order was issued, but without citing the reasons for this cancellation. So this was the case of Tripura, where Honorable Tripura High Court has said that, okay, this is not the correct method. So you cannot give such or cancellation show cause notice without specific ground. So these could not be vague one, and therefore it was quashed. And this was the case that between the distance dispatch point and the destination point, time was over, and they wanted some extra time. And department who intercepted the cargo or the truck, they said that they are trying to evade tax, and they said that we don't have any intention to evade tax. It has gone delay because of e-way bill validity was less, and therefore court said yes, you should be. Yes, in this case, validity should be extended rather than levying penalties on this. So I think we can take question answers also, or after 8 we will take question answer.
Thank you so much, C. Abhishek Raja ji, for such a wonderful session. Like, I believe everything has been taken very much in detail, that we haven't received even a single query by any of the participants. Means that all of them grasped each and every word that you spoke on this platform, and there's no question of any doubt. So it was truly an honor to have you on today's VCM. And
sir, it could be reversed also.
सर रिवर्स
मैंने इतना खराब डिस्कशन करा है कि there are no queries.
सर हम तो हमेशा पॉजिटिव होके चलते हैं, हमें इतना पता है कि जो समझाया, because I have been there in this session from the very beginning, and there was nothing which I couldn't understand or nothing which created any question in my mind while we were deliberating on this topic. So it was truly an honor to be one of the participants here, and to be given this opportunity to host you on this platform. And sir, it's really amazing to see how the law, which was created back in 2017, it has been shaped through these judicial pronouncements by various AARs and various high courts and Supreme Court. And I believe that this law is going to mutate further through these judicial pronouncements. And it was really great to know what judgments have been passed by the judicial authorities, and it would not have been possible without your support and without your knowledge, that we would have got to know all these things. So thank you so much for being here. And now I would like to invite the chairman of Hisar branch of NIRC of ICAI, CA Bharat Jain ji, for the final vote of thanks. Over to you, sir.
थैंक यू पुनीत जी. अभिषेक जी, मैं आपका तहे दिल से धन्यवाद देना चाहूंगा. आपने टाइम निकाला और इतनी लेट नाइट में शायद आप ऑफिस में हैं अभी प्रोग्राम देने के लिए. और आपके प्रोग्राम सर मैं जैसे बताया था पहले हमेशा से सुनता रहा हूँ, और पीछे जब जीएसटी का आपने एक ये किया था कि जीएसटी की आत्मा ही खत्म कर दी, तो वो वाला भी सर मैंने खूब सुना आपका, और अब हमेशा रिगार्डिंग बोलते रहते हैं सर, ये बहुत अच्छा है। आप किसी के मतलब अगेंस्ट भी बोलते हैं, इनके गवर्नमेंट के अगेंस्ट है जो भी है, अब ट्रू फैक्ट लाते हैं सामने, और ये सर आपकी अच्छाई है सर। और सभी ऑडियंस का भी धन्यवाद देना चाहूंगा जो आज जुड़े हैं हमारे साथ। पर अभिषेक जी मैं आपको चाहूंगा कि भी आप इस हार मतलब फेस टू फेस प्रोग्राम में भी अगर आप समय निकाल सकें।
जरूर सर,
मैं सर आपसे करता हूँ कॉन्टैक्ट है। थैंक यू सर। थैंक यू पुनीत जी।
Thank you so much, Bharat ji. So we conclude our today's session, and it was really wonderful to have all the eminent speakers here, and it could not have been any better. Thank you so much.
Thank you, everyone. And this is Deepika from CPE committee. Thank you, everyone. And thank you, sir, for giving us such a precious time and deliberating on such a great session. Thanks a lot. And thank you all for giving your 3 hours of your life. That's a very important part of the things, that because right now we don't have so much things to give anyone. There is only time which we can give to each other. Thank you.
Thank you, ma'am.
Thank you so much. And this will conclude our session. Thank you. Take care and have a be safe. Bye.